For more than 100 years, in New York and a handful of other states, ordinary law-abiding adults who wanted to carry a handgun for self-defense had to prove they faced a special need, something beyond the everyday dangers the rest of us live with. A shop owner walking to her car after closing, a commuter riding the subway at night, a parent picking up kids from school. None of them qualified unless they could show something extra. Then, on June 23, 2022, the United States Supreme Court handed down a 6-3 decision that didn't just strike down New York's rule. It changed the constitutional standard that every gun law in America must now meet. That ruling is New York State Rifle and Pistol Association versus Bruen. And today, we're going to walk through exactly what it says, why it matters, and what it actually means for your daily life. Without the hype, without the panic, just the law as it stands. So here's the question I want you to think about right now. In a country where the right to bear arms has been debated since the founding, does extending that right more fully to public spaces make us freer? Or does it demand we rethink how safety and liberty balance in the 21st century? Drop your honest take in the comments. I read every one, and it's fascinating to see how this lands differently depending on where you live. Let's start at the beginning, because no Supreme Court case exists in a vacuum. The Second Amendment is only 27 words long. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. For decades, lower courts treated the first half, the militia clause, as the main point. The right belonged to the collective, to organized state militias, not to individuals walking down the street. That view held until 2008. In District of Columbia versus Heller, a 5-4 decision, the Supreme Court finally said what the text has always suggested to many scholars. The Second Amendment protects an individual right to keep and bear arms for self-defense. The court struck down a Washington, D.C. handgun ban inside the home and made clear that the inherent right of self-defense has been central to the Second Amendment right. But Heller left one big door open. What about carrying outside the home? The court didn't need to decide that question then. 2 years later, in McDonald versus Chicago, another 5-4 ruling, the justices incorporated the Second Amendment against the states through the 14th Amendment. Now the right applied everywhere in the country, not just to federal laws. Still, the public carry question lingered. Most states had moved to shall issue permitting systems, objective background checks, training requirements, no subjective discretion. But a few states, including New York, stuck with may issue or proper cause regimes. Licensing officers, often judges, could deny a permit unless the applicant proved a special, individualized need for self-defense. Enter Brandon Koch and Robert Nash, two law-abiding residents of Rensselaer County, New York. They already held restricted licenses for hunting and target practice. They applied for unrestricted concealed carry permits so they could protect themselves in public. The licensing officer denied them. Their neighborhoods had seen robberies, but that wasn't enough. They needed something distinguishable from that of the general community. So they sued, arguing the Second and 14th Amendments gave them the right to carry for ordinary self-defense. Lower courts upheld New York's law, citing decades of precedent that applied intermediate scrutiny, basically asking whether the regulation was substantially related to an important government interest. Public safety qualified, so the law survived. The Supreme Court took the case in 2021 and heard arguments in November of that year. Justice Clarence Thomas wrote the majority opinion for the 6-3 court. Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Barrett joined him. The holding was straightforward but revolutionary in its reasoning. New York's proper cause requirement violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms. Here's the part that changed everything. The court threw out the two-step framework that lower courts had been using since Heller. Step 1. Does the law burden conduct protected by the Second Amendment? Step 2. Does the government have an important interest and is the law reasonably related to it? That second step, interest balancing, is gone in the Second Amendment context. Instead, the new test is this, and I'm quoting Justice Thomas directly because the words matter. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Text, history, and tradition. That's the new measuring stick. If the law regulates something the plain text protects, keeping and bearing arms for self-defense, the government has to show a historical analog from the founding era or the periods when the 14th Amendment was ratified. Not a perfect twin, but a representative analog that imposes a comparable burden for a comparable reason. The majority walked through centuries of history: English common law, colonial statutes, founding-era laws, Reconstruction-era protections for freedmen, all pointed to a right to carry arms in public for confrontation. Sure, there were regulations, bans in sensitive places like courthouses or polling places, surety laws requiring someone to post bond if they threatened others, prohibitions on carrying dangerous and unusual weapons. But a flat requirement that ordinary citizens prove a special need? No historical match. Justice Alito wrote a concurrence emphasizing that the decision doesn't affect objective shall-issue licensing. Background checks, training, fingerprinting, mental health disqualifications, those stay. Justice Kavanaugh and Justice Barrett wrote separate concurrences making the same point and noting that the court wasn't touching felon in possession laws or other long-standing prohibitions. The three-justice dissent, written by Justice Breyer and joined by Justices Sotomayor and Kagan, focused on the real-world stakes. They argued that the history-only approach ignores modern gun violence statistics, mass shootings, and the unique dangers of urban environments. They believed courts should still weigh public safety interests. The majority responded that the Constitution's text and history set the boundaries. Judges aren't free to rewrite them based on current policy preferences. This is educational content only. Nothing here is legal advice. If you're dealing with any specific situation involving firearms or permits in your state, please consult a qualified attorney who knows your local laws. Let's clear up a couple of common misconceptions that still float around. First myth: the Second Amendment was only ever about militias. Heller already settled that in 2008. The well-regulated militia clause explains why the right exists, but it doesn't limit the right to militia members. The court looked at the text, contemporary usage, and history, and concluded the right belongs to the people, the same phrase used in the First and Fourth Amendments. Second myth: Bruen means there can be no gun control at all. That's simply not true. The opinion explicitly says the Second Amendment is not a regulatory straitjacket. States can still require permits with objective criteria. They can ban carry in sensitive places with historical roots: schools, government buildings, polling places. They can prohibit felons, the mentally ill, and domestic abusers from possessing guns, as long as those prohibitions have historical analogs. What they can't do is condition the right on a subjective showing of special need. Third myth: Bruen turned America into the Wild West overnight. In practice, the states that switched from may issue to shall issue, New York, California, New Jersey, Hawaii, and others, still require background checks through the National Instant Criminal Background Check System, safety training, and character evaluations. Permit denial rates didn't collapse to zero. Law-abiding applicants still have to qualify. What changed is that licensing officers lost the power to say, "You don't need it," when the applicant meets every objective requirement. So what does this actually look like in everyday life? Picture a nurse finishing a late shift in Buffalo. Before Bruen, if she applied for a concealed carry permit, the licensing officer could deny her because everyone feels unsafe at night. After Bruen, she submits her fingerprints, passes the background check, completes the required training, and, if she meets the criteria, the state must issue the permit. No more discretionary veto. Or consider a small business owner in Manhattan who travels between boroughs carrying cash receipts. The old system forced him to prove threats specific to him. Now the process is objective. That's the practical shift for millions of Americans in the former may-issue states. The ripple effects went far beyond permitting. Because the new test applies to every gun regulation, plaintiffs across the country filed challenges to assault weapon bans, large-capacity magazine limits, red flag laws, and even some federal restrictions. Lower courts are still sorting through them, asking the same question in each case. Is there a historical tradition of regulating this particular conduct this way? Some laws have been upheld, others struck down. The Supreme Court itself, in United States v. Rahimi in 2024, showed how the test works in practice. An 8-1 decision upheld the federal ban on gun possession by people subject to certain domestic violence restraining orders because the historical record supported temporarily disarming people who pose a clear threat of violence. What Bruen does not do is eliminate all disagreement. Supporters of the decision argue it finally treats the Second Amendment like every other enumerated right. No second-class status, no interest balancing that lets judges substitute their policy views for the Constitution's text and history. Critics argue the history and tradition test is unworkable for modern problems, that judges aren't historians, and that it handcuffs elected officials who are responding to contemporary gun violence. Both sides have a point worth hearing. The Constitution's original meaning should bind us, yet applying 18th and 19th century analogs to semi-automatic firearms and urban density requires careful, evidence-based analysis. That's why the post-Bruen litigation is still unfolding in 2026, and why understanding the framework matters. Has the decision affected your life yet? Maybe your state changed its permitting process, or you've noticed more open discussion about carry rights in your community. If it has, or if it hasn't, let me know in the comments. Real stories from real people help all of us see the human side of these constitutional questions. Let's pull this together with the 3 most important takeaways. First, the Second Amendment now clearly protects the right to carry a handgun in public for self-defense, not just inside the home. Heller gave us the home. Bruen completed the picture. Second, every gun regulation, state or federal, must now be justified by reference to the nation's historical tradition of firearm regulation. Interest balancing is off the table. That single shift has already forced legislatures and courts to rethink decades of assumptions. Third, objective, non-discretionary licensing systems remain constitutional. Bruen did not create a constitutional right to carry without any screening. Background checks, training requirements, and prohibitions on dangerous individuals are still on solid ground. Why should any of this matter to you if you're not a gun owner? Because constitutional rights are interconnected. When one right is treated as second class, it sets a precedent that can affect speech, religion, privacy, all the protections that define a free society. Understanding Bruen gives you the tools to evaluate new laws, court decisions, and political arguments with clarity instead of fear or slogans. More practically, it affects how safe you feel walking to your car, traveling across state lines, or deciding whether to take a firearms safety course. The law now starts from the premise that law-abiding citizens don't need to beg permission to exercise a fundamental right. This area of law is still evolving. New cases will reach the Supreme Court. Lower courts will refine the historical analog inquiry. But the core principle Bruen established is now the law of the land. The right to keep and bear arms is not a privilege granted by government grace. It is a constitutional guarantee that government must respect unless it can prove a consistent historical tradition for limiting it. That's a powerful shift. And whether you celebrate it or worry about it, knowing exactly what the court said and what it did not say equips you to participate in the conversation as an informed citizen. Thanks for spending this time with me. If this video helped clarify one of the most important constitutional developments of our lifetime, do me a favor and share it with someone who might benefit. Stay safe, stay informed, and I'll see you in the next one.